well as Ms. Lopez here. She may come up, I think the court might need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay.
If you've gotten to the point where you're frustrated, Ms. Lopez, you know there's an issue.
So are we going to go through the motion? Are we,
Yes, please, Your Honor.
so let's do that first. Good morning, Ms. Lopez.
Good morning.
And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So I.
Give me just a second to get that pulled up. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to. True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right?
Yes, ma'am.
Okay. Count 7 alleges that you failed to,
I think it should say not in there, Judge, I'm sorry. He failed to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration means? If the court could explain adult, I don't think he.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No,
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that, or not? That you admitted to drinking something?
So it says you admitted to the adulteration of your urine analysis, which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
well, any piss test,
Urine test.
Listen.
Urine test, I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
this say not true?
Count 10, let's see, actually count 9. Hold on, I'm not up. 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You say it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick.
Hey, David. David.
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Okay.
Weaver? Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there. I apologize.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to this.
So, last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week and she admitted that they had been seeing each other that day. And she was angry but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you,
They come back in front of you.
Just be quiet, listen.
I told you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spinal top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report. We can have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then...
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
but my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell?
All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR 1863 charged with possession of marijuana, 25 DCCR 1149 charged with evading arrest or detention with the use of a vehicle, 25 DCCR 1150 charged with unlawful possession of a firearm by a felon, and then 24 DCCR 0841 also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those two previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least two additional felony offenses, we would ask, just based on the totality of the circumstances, the nature of the offenses themselves, the court raised all of those bonds and place him back in custody. And I will provide discovery to Mr. Kimler on the two new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those two, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the two new offenses are after the other two offenses, is that right?
Yeah, so the offense dates on the two, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got two new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by felon of this year. So give me just a second to review all of this, and then I'll let you.
Got time? There's a funky object.
You make sure you sign it.
Sorry, I should have had these done already.
Maybe it's.
Got one more I'm coming, I think. Oh wait, that's what I'm missing. 08. All right, so let's see. On the two older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those when the two new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door and midterm.
So we've got, here's the,
We're gonna just go with the Class A amendment. Yeah, he's gonna try it. So this will be less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's mine.
Let's do A, that's what we're doing.
Thanks, honey.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same, and then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I thought
That's three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be
find?
the same, probably the same PC for
Two
each case.
same.
Evading
Two printed.
0841. I didn't just print this one?
And two of them look just the same, but there's still stuff in it.
Okay, maybe that's it.
This stuff's just there.
Why did it do two? What's happening? Okay.
I'll sign it out. Is this a lot?
So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct, where he served 1 year in jail.
Mr. Kimler?
Well, yeah, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's your employee, is that correct?
What's on the report? Yes, sir.
Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous two cases, I would suggest a GPS device in lieu of an increased bond.
I don't see how a GPS is going to help when you're out on bond, you've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but I'm no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case for an announcement. for the cases. If I don't do that now, I'll forget. And this is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory?
Ma'am.
All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants him to have psych evaluation because he does have, he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information, that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have a no unsupervised time with the child. Are they still together?
No, this happened last year, so they co-parent. I talked to her last week, so she said she didn't want the no contact. So that was our issue, because I talked to her and she was like, she doesn't agree with that because they co-parent well, and she's in school, so he has the child while she's in school. But Mr. Coleman said he talked to her in June, and so she did tell me, she said, well, at the time they weren't on very good terms, so she might have told Mr. Coleman she didn't want. But now, she said they are on good terms, and so that was our issue, you know.
I've got notes in my file contradictory. I'm not doubting what,
She said,
Ms.
yeah.
Hall's version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year ago.
Complaining.
Okay, so the
And
August
she's
of
not the
24.
complainant, she had nothing to do with it.
She's not.
Well, mother of the child.
Yeah, so she had nothing to do, like, she wasn't on the scene, she wasn't.
Is she
Since
here?
we're doing a
No,
lot of
she's
this-
not.
Since we're talking a lot about extraneous things, Judge, and what other people say and don't say, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her, so.
But you haven't heard anything since then?
No, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still in, you and the mom aren't in a
We're not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay, so let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been. And then, have you been receiving any treatment for any diagnosis
I
that
did go
you?
to spinal tap, and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that regularly?
No, ma'am, not currently.
Well, that causes me concern.
Yes, ma'am.
So,
I haven't been on it in more than 6 months.
why?
I'm having transportation issues getting back to spinal tap.
Okay. How do you get your child? And,
My baby mother will drop him off to my house.
okay, you're gonna have to go to, because of the nature of what you're saying that happened, and even though if she was under the influence, if there was some threats that had to do with that and some mental health issues, then at least and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to spinal tap when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's gonna be a part of your probation now.
Yeah.
So you need to figure out a way to get there, you need to figure out, they'll help you with medication, whatever it is. And, I wanna know what you're on, what you're taking, and that you are following through with everything so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, we're gonna be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, for your mom.
Do y'all didn't do paperwork already
I
though?
have it here.
Okay, yeah, I'll hold it while y'all get that
So
done.
what
I'll
do you want
recall
me
it.
to- Because I didn't put as far as the agreed recommendation, him having no contact with his.
You don't have to put it as an agreed recommendation, I'll order it.
No contact?
Judge, what I intended with the state, I recognize for the purposes of child exchange, there has to be some type of working.
Oh, yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part, so I'm not gonna order no contact with her. I'm going to order supervise with the child, because it sounds like that is what the underlying offense had to do with, not her.
Okay.
So y'all can either agree to mark it off, or I'll do it when it comes through. If you wanna argue for it, that's fine, Mr. Coleman, but no, I'll allow him to have contact. You can have phone conversations with your child, you can FaceTime between now and then. I just don't want if there's a supervised, y'all can if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something. No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense?
Yes, ma'am, it does.
Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue.
Yes, ma'am.
But I would say it's not gonna be at her house. I want y'all to be somewhere public. That's not a good idea. Okay.
Yes, ma'am.
Y'all go take care of that paperwork and
So
I'll
what
take
do
care
I-
of it. Y'all,
What do I put? Do I put as a condition, as a probation condition, supervise it, or?
no, because that's gonna be a bond condition.
Yeah.
I'll say it when y'all
Okay,
come back
okay,
up.
Okay, so I won't write it in, okay.
Yeah,
I guess right now.
just have to see, yeah, y'all can go over that paperwork and then I'll
Okay.
recall it in just a minute.
This is the forfeiture.
Okay, I just didn't know if you want to hold on to it.
Yeah,
Okay.
I just sent it to you.
Good morning, you're Seneca McDaniels, and what is the announcement?
Judge, with the court's permission, based on the underlying facts of this case themselves, we have agreed to forfeiture of this weapon. He has brought payment already today. We just need to figure out who to make it out to, and he's going to plead down the hall, hopefully in 2 weeks. We can get into county court through from his home.
So what I'll do is just a normal reset here that should all hopefully be taken care of. If for some reason that's not taken care of before the court date here, make sure you show up when Ms. Holmes tells you to, okay? Okay, you're free to go. All right, of course, do y'all have the paperwork on the tablet over there?
Our tablet died, Your Honor.
Okay,
Sorry, I should have probably.
There's another one over here.
can y'all,
Well, this,
You didn't load me out.
okay.
Yeah, it's on there.
what is, plea bargain on a Brian Mitchell, still on my tab, what did I do on that?
Just to take a fingerprint. It's a reject, right? It's something like filled it out. Hold on.
Yeah, right, it's gonna be right.
You got your,
That's the forfeiture and the discovery.
No, I'm not agreeing on it, it's all.
Does the attendant take it down to the washroom?
yes ma'am, Class A. Okay, on, Rolling Guillory, again, you're Rolling Guillory. And will your client waive the formal reading of the indictment?
Big Your Honor.
Mr. Guillory, in cause number 24, DCCR 1568, the state is elected to proceed on the Class A misdemeanor lesser offense of attempted endangering a child from March 15th of 2024, and how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am, I did.
And do you fully understand
Yes,
them?
ma'am, I did.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am, I did.
And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Part of this agreement also is to forfeit the weapon, which I've already signed that order, and also to have a psychological evaluation and to follow all of the recommended treatment. Do you understand? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Guillory is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I am going to get a pre-sentence report done on this case. I am going to ask Kristen if this is something that you guys can kind of do in maybe 4 weeks instead of 6, and then we'll come back for sentencing. A condition of bond between now and then, a couple of things that we've already talked about, but now that we're going through this, I'm going to make sure everybody's on the same page, is that you're not to have any unsupervised visits with your child. That's so you can still have them or meet, do whatever, like we talked about, so that I can get that pre-sentence report and see what's going on. Also, you need to immediately get an appointment with Spindletop. Hopefully, you will have time to go to that appointment before the next court date. Bring documentation of anything you've done, any medication they've prescribed, and things like that. And then at that court date, depending on what all that shows, then we'll get back to, at some point, I'm sure fairly quickly, you having your son again. But I just want to make sure everything is on track and that you are in a good position as well as your son.
Yes, ma'am.
Okay? You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? All right, we'll see you back at sentencing. Oh. But I'm not even clicking it, and it's just moving.
Sometimes it just does click.
Put the X.
Now grab it.
I can't see it over here still.
There you go.
Don't call me mom.
Wait a second. Okay. All right, you're Daniel Spencer Ybarra?
Yes, ma'am.
And Mr. Kimler, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
It looks like we're going on the entire, all of the,
This is second
Yes,
degree.
ma'am.
okay,
Yes,
so Mr. Ybarra, in cause number 24, DCCR 1722, you're charged with the state jail felony offensive theft with previous convictions. That's from April 28th of 2024. And the indictment alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, 2 cases on February 7th of 2007, September 27th of 2010, May 4th of 2011, and then the indictment,
Oh, I'm sorry.
I know, but he's trying to pay attention to me. The indictment further alleges that you were previously convicted of burglary of a vehicle, a third-degree felony, May 19th of 1986, in 2 cases. And then after those were final, you were convicted of delivery of marijuana, a third-degree felony, November 30th of 1987. Also, delivery of marijuana that same date, November 30th of 1987. And after all of those were final, you were convicted of prohibited substance in a correctional facility, a third-degree felony, July 31st of 1999. And after that was final, you were convicted of driving while intoxicated, a third-degree felony, January 5th of 2000. And after that was final, you were convicted of driving while intoxicated, a third-degree felony, October 29th of 2009. And how do you plead to that charge?
And I'll get the volume.
So you're guilty of the offense you're charged with, and are all those priors true?
Yes, ma'am.
And then in cause number 24, DCCR 2289, you're also charged with the state jail felony offense of theft with previous convictions. This is from September 28th of 2024. It alleges all of those same prior offenses, and how do you plead in that charge?
You have to verify now.
Did you enter your pleas of guilty and true in each of these cases freely and voluntarily?
No, I did.
And because you're guilty, you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
And do you fully understand them?
Yes, ma'am, I did.
And do you understand if I follow any agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am, I did.
And it looks like the agreement that you've reached is for a cap of 10 years. The way the allegations and the prior convictions make these for punishment purposes a second-degree felony. The agreement is to cap your punishment at 10 years. Leave it up to me. You have an absolute right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then secondly, to leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am, it is.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. And also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I do.
And is there any evidence that Mr. Ibarra is not competent?
None of my knowledge, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases so that the probation department can do a pre-sentence report, and then we will come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Kimler and the pre-sentence officer, and then when you come back, they will present it to me on your behalf. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there.
Thanks, Your Honor.
All right, we'll see y'all back at sentencing. Good morning. You are Brian Tipton, and will your client waive the formal reading of the indictment?
He does.
Mr. Tipton, in cause number 25, DCCR 0149, you're charged with a state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with your attorney? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tipton is not competent?
There is.
And is there any criminal history, any reason not to waive?
Judge, he has criminal history. It's older, but there is criminal history, so I think we need to do a PSI.
Okay. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there. All right, we'll see y'all back at sentencing. Thank you. Oh, I need the discovery certification. Thank you. And if you'll make sure and get that attachment emailed to the clerk. Thank you. Good morning. Are you Cedric Fontenot? Speak up, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Fontenot, in cause number 24, DCCR 1665, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up.
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yeah.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
And what about this one as far as history?
This one only has traffic.
Okay, so any issues with waiving the pre-sentence report?
Yes, Your Honor.
All right, so Mr. Fontenot, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 3 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty, which means you'd be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? Also, if you get on this probation, do everything you're supposed to up front, get it all taken care of. I sign early terminations from probation every single day. So if you do it, you don't have criminal history, I have no doubt that you'll be able to be successful. If you get community service, get everything taken care of, it's likely that you can get off before that 3 years as well. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk to go over your paperwork when she's ready, and she's at that desk right over there, so be watching for her to call your name. Good luck to you, sir. Thank you.
Thank you, Your Honor.
Non-cooperation, cooperation. Non-cooperation, which I believe is still the case. I don't know what
Look this way.
I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, and that in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well, that's why-
They're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
Okay.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our manager on the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay.
But
then
he's
it's
been staying there.
all right. Well, then you know what you have to do. You're the one
I
on.
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house and you're, I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm trying to have another child for him. How are we supposed to, how are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Now we're ready to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go. You're Brian Mitchell? And Mr. Mitchell, in 24 DCCR 0170, is charged with aggravated sexual assault of a child. Case set for trial to begin with jury selection on Monday, the 29th. And what is the announcement?
We're ready. Can I just have a second, because I thought it was next week.
Yeah, we're down next week. The DAs are all.
I had one over in Orange, Judge, that that wasn't Judge, we just after.
You're good on the 29th?
Yes, Your Honor.
Okay, all right, so I do want to make sure that after today, there will be no plea agreements accepted. Your case is likely to be at the very top of the list. It's one of the older ones, and so is there any change with regard to negotiations or anything like that?
No, Your Honor.
Okay, we'll see you back on the 29th then. I'll number the cases tomorrow after docket, and make sure you stay in touch with Mr. Burbank. He'll know the exact trial trial order tomorrow after docket. Okay? Yes, thank you. Good morning. Are you Tate Daly?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Please hold on.
Let's see, we're going on 179. Mr. Daly, in cause number 25 DCCR 0179, you're charged with the state jail felony offense of driving while intoxicated with a child under 15 from September 2nd of 2024. And how do you plead to that charge? Speak up.
Speak up.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a $1,000 fine, follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
In addition, as part of this plea, the state would dismiss cause number 25 DCCR 0180. Is that also your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Daly's not competent?
There's none, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? Well, yes, sir.
And Your Honor, for the court's information and also for the record, the endangering case under cause number ending in 0180 is not only being dismissed as part of the plea in this case, but also because it is the underlying facts are the same as the DWI.
Okay, perfect. Thank you. I'll sign that dismissal. Looks like it's already come through. So just stop and talk to probation on your way out, okay?
Yes, ma'am.
Yeah, okay, thank you.
All right, we'll take a list now.
All right, sir, your Tejuan Mack,
Yes, ma'am.
and this is 24 DCCR 1046. Mr. Mack's charged with criminally negligent homicide, set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
Let's read.
State's ready, Judge.
All right, I do want to make sure that after today, y'all understand that I will not accept plea agreements.
Understood.
And it's likely to be pretty high up on the list, depending on the other cases. Mr. Mack, you want to go forward with your trial on that date, is that correct?
Yes, ma'am.
We
Okay.
requested a speedy trial, so we
Well, Well, it's
I understand, I
set in
was,
2 weeks.
I know, but as far as a trial order, we have requested this.
I understand. The other case, though, is a child case, which would take precedence if that one in fact goes, but this is likely to be probably the first backup to that, potentially. So
So you
we'll
want
see
him-
what else I have.
I think there's Batiste on there, Judge, I think he may be in custody.
Oh, he is.
It's somewhat held.
It is actually, so here's the thing, I will number the cases tomorrow. Stay in touch with Mr. Kimmler. He'll know tomorrow after my docket what the trial order is and when you need to be back. Okay? All right. And Terry Mahler, Mr. Kimmler, do you need to visit for a minute?
No, I believe she has the restitution.
Well, not all of that, 1,000 of it.
Y'all go visit then. Let me know what's going on.
It's 2,500 left.
Go visit and I'll,
Yes, Your Honor. Hang on a minute. That's it.
Richard Robb, Mr. Kimmler?
I did a refusal on that, Your Honor. I'm sorry, we're gonna reset that one. I'm sorry. That's what we're gonna reset. She needs some time to look at that. Just a minute.
Mr. Robb, come on up, sir. Good morning, sir. You're Richard Robb?
Yes, ma'am.
And this is 24 DCCR 2170. You're charged with theft of property, and what is the announcement?
Your Honor, the state's offered felony deferred probation. We've countered with misdemeanor. I think the prosecution wants to review the file.
If the court would just give me a week or two, Judge, to determine if the restitution, if the item was returned, obviously the restitution will not be there. That's what our issue was, and then I'll offer
All right.
misdemeanor lesser included.
We'll reset it about 2 weeks.
Thank you, Judge.
Stay in touch with Mr. Kimmler, all right? And your bondsman, they'll let you know when you need to be back. We don't do that.
Oh, yeah,
Just
okay.
stay-
Go ahead and go, Your Honor.
Your Honored Souls?
Yes, ma'am.
Mr. Souls, what made you think that wearing that kind of clothes or shorts to court would be appropriate?
I apologize, Your Honor. When I came this morning and I looked at the door, I never really paid attention to the door.
But even, how old are you?
I'm 38.
You're 38 years old. You've been in courts before
Yes, ma'am.
because you have felony convictions, right?
Yes, ma'am.
So have you ever been able, or it was okay to wear shorts in court?
Like my parents, Your Honor, Kakashu, they allow us to wear shorts. And I was kind of rushing to get out of here. So
That's
I packed-
interesting.
I packed my bag and I came to court. I apologize.
Okay, don't wear shorts again. That is not appropriate here in felony court, do you understand?
Yes.
Or in any court in Jefferson County.
In Texas.
Yes, sir.
So, Mr. Souls, in cause number 25 DCCR 0252, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from November 1st of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have a plea bargain rejection here on the tablet that has your signature on it with Mr. Kimmler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 4 years, which means you would leave your punishment up to me. I couldn't give you more than 4 years. I could give you 4, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and let a jury decide. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. You need to stay in touch with Mr. Kimmler and your bondsman. They will let you know when you need to be back and ready for trial. Okay, you're free to go. You are Daniel Yarborough?
Yes, ma'am.
And Mr. Yarborough, in 24 DCCR 1722 and 24 DCCR 2289, charged in each of those cases with theft of property. The cases are set for trial to begin with jury selection Monday the 29th. And what is the announcement?
Your Honor, I'm ready. I do think Mr. Barbo has endeavored since our previous setting to go through rehab and has accomplished some things. And I'm going to provide to Mr. Coleman that may perhaps change the plea offer, but I am ready for trial. But we do have additional stuff I was going to tell you in the prosecution.
Judge, this case, in all honesty, should not be on the trial docket. I am willing, if the court will put this case on recall, to take a look at what he's providing. I may make an alternative offer. Unfortunately, the file's not in my bucket. I need to get someone to bring it.
I'll hold it while y'all take a look at all of
You
that.
want to say something?
Just,
Would love to.
y'all,
Judge, I
hang
think
on.
this is inappropriate.
Yeah, not yet. Y'all visit. This is between y'all right now, okay?
He needs to hear that from you. I try to tell him.
Looks like he's got something. Thank you. All right, again, you are David Holland? And Mr. Boudreaux, will your client waive the formal reading of the indictment?
Yes, ma'am.
Hold on, just a moment.
Judge, while you're pulling that up, I'd like to state that, I looked up this defendant's jail credit. It looks like he's already got 2 days jail credit to go toward, his sentence in this part of his plea. And also, I have no reason, while it's under the sheriff's discretion to grant 2 for 1, I have no reason to doubt that he wouldn't get the 2 for 1 as customary there at the jail. But again, it's for the total to the sheriff.
Right. Okay. Thank you. Let me get this. So we're going on count 1. Well,
Lesser
count
included.
1 and the lesser included.
Yes, ma'am. The state would abandon the additional counts, all but paragraph 1.
And in that count to the lesser included.
Yes, ma'am.
Thank you. Okay, Mr. Holland, in cause number 21-36992, the state is elected to proceed on count 1 only, and in that count to the lesser included offense of theft from October 6th of 2020. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Boudreaux? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And the agreement is for 30 days in the Jefferson County Jail, and you understand. And you'll get whatever credits you already have, and then what the jail does with regard to 2 for 1 or anything like that is up to them. And are you a U.S. citizen? And you're ready, and and you understand you'll be going into custody today, correct? Okay. State tenders number 1.
Yes, ma'am.
Any objection to states number 1?
No, ma'am.
It's admitted. Is there any evidence that Mr. Holland is not competent?
Yes, ma'am.
Is there any evidence that he's not competent?
No.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor theft, sentence you in accordance with that agreement to 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. There you go, and then you can just go back with the bailiff. That's for him. And Mr. Coleman, would you mind helping out with that discovery certificate, the attachment?
I'll give it to Ms. Warren.
That's for your client. That's his.
Give it to him.
Thank you, Judge.
Thank you, and thank you.
Brandon Bell's probation revocation hearing demonstrates how deferred adjudication depends on strict compliance with every court-ordered condition and how repeated violations can quickly undermine a defendant's opportunity to avoid a conviction. The judge methodically reviewed each allegation, requiring clear admissions or denials before considering the broader circumstances, emphasizing procedural fairness while maintaining firm courtroom control. Bell admitted to multiple probation violations, including repeated positive THC tests, unauthorized contact with the victim, curfew violations, failure to complete required programming, and unpaid court obligations. The court also expressed serious concern that both Bell and the complainant continued disregarding the no-contact order despite repeated warnings, concluding that the ongoing relationship created safety risks and justified revoking his bond and ordering him held without bond pending further proceedings. Throughout the hearing, the judge stressed that probation is a privilege conditioned on accountability, treatment compliance, and respect for protective orders. The case serves as a reminder that even when parties wish to reconcile, court-imposed conditions remain legally binding until modified by the court, and repeated non-compliance can result in significantly more restrictive consequences.